All right. Thank you, Braden Wayne, for joining us today to discuss dental legal issues. Braden is an attorney out of Dallas, Texas, that focuses on dental practice matters such as issues common to buying a new practice and what to look for in contracts when becoming an associate dentist.
Thanks, Ants. Appreciate it. As Ants just said, my name is Braden Wayne, and I'm an attorney in Dallas, Texas, with the law firm of Steckler, Wayne, Cochran, and Cherry. My practice is focused on dentists and DSOs, specifically in connection with transactions as well as ongoing legal issues relative to the operation of dental practices and dental service organizations. Just here to talk a little bit about the ethics of law and dentistry. Legal ethics can be a little bit of an oxymoron because it's about what is the least ethical option you can take that's going to keep you out of trouble. But obviously, when you're dealing with professional service providers and healthcare practitioners, the ethics play a much larger role. So happy to be here and talk to you guys about law and dentistry.
Thank you so much. We'll go ahead and start with our first question. So we'd love for you to talk about a little bit what parts of our contract are negotiable and what parts are not.
Sure. So this is obviously going to depend on the organization you're signing up with, whether it's a single shingle dentist or a large multi-practice DSO or just a multi-practice dental group. But you've got different parts of an associate employment agreement that you can generally negotiate. I like to distinguish between economic terms of the agreements that you can negotiate and then the legal terms of the agreements that you can negotiate. So obviously, the first thing that generally pops up is compensation, right? And this is going to depend on the type of dentist you are, whether you're a specialist or whether you're a GP. But generally, you're going to be paid one of three different ways. If you're in ortho or some sort of specialist, you might be paid on a per diem. That's obviously negotiable based on the number of days you're going to work in a given year. Just prorated out based on the salary you're looking to make. With GPs, a little bit different. You can either be paid on adjusted production or some sort of formula based off of production, or you can be paid off of collections. This is all negotiable, although generally a practice is going to have, they're going to have a preference as to whether you're paid off of production or collections. It's easier from a firm or a practice administrative standpoint if they can pay, if all the doctors are paid based off of collections or all the doctors are paid off of production. Production's what it sounds like. It doesn't matter whether the practice actually collects the money from the patient or not, or gets paid from the third-party payer. You're going to be paid based off of what you produce, just from a billing standpoint. Generally, that's going to be anywhere from 28 to 33, maybe up to 35% of your adjusted production. What's important to look for there is, okay, what are you producing? What are the fee schedules like that you're working with? And then what are the adjustments that are going to be taken down off of your production, whether those are Medicaid adjustments, rebates, coupons, stuff like that, that could end up impacting what your actual production is. So very important to pay attention to what type of adjustments your specific practice is going to take off of your production. When you're working with collections, you're going to look at a little bit of a higher percentage because collections are generally a little bit lower than production, just because you've got AR issues, uncollectability issues, billing errors. You're going to be looking anywhere from 30 to 40%. I've seen as high as 42% of collections. But again, it just depends on, what the fee schedules are like, what the payer mix is like, and what the practice collection history is as it relates to its patient or its third-party aging. So really important to get in and not just pay too much attention to the specific percentage, but really I would have, a dental practice, if you're looking at negotiating your contract, kind of put out a pro forma, okay, here, if this is what we expect you to produce in a year, here are the adjustments you're going to get hit with, here's your production percentage or your collection percentage, here's our collection rate. And really work it all the way back down into what you're going to be able to take home. But again, all of those, generally at least, all of those provisions, whether it's the specific percentage or the specific adjustments that are going to be made, those are all negotiable. but your practice likely will have a preference as to whether you're paid collections or on production. Another thing to pay attention to is what is included in production, because not everything you bill might get billed out in terms of under your provider ID. If you have hygiene production or hygiene radiographs, a lot of times those specific codes aren't billed under your provider ID. They might be billed under a practice ID or a house account. So it's important to pay attention whether or not those are going to be included in your compensation, because those can be a big player. The other economic term you're going to want to pay attention to is malpractice insurance, which can obviously be very expensive and is going to depend on whether you're a specialist or a generalist. But important to know whether that's a practice expense, where the practice is going to be paying that on your behalf, or whether that's something that you're going to be responsible for paying for. The practice would obviously get it for you, and then the cost of it would be deducted from your payroll. That's generally what you're looking for in terms of the economic provisions. The other item that comes up a lot, especially with new dentists, is signing bonus. You see signing bonuses quite a bit, especially if you're moving states or moving areas. You can get a moving stipend, or relocation stipend or bonus, and then you can get a signing bonus. And I've seen signing bonuses anywhere from I've seen them from $2,000 all the way up to $30,000 or $40,000 in really unique scenarios. And generally, a signing bonus, and not a lot of people realize this when you sign it, because you get it up front. But your signing bonus is going to be tied to your employment term. So let's say, just to use easy numbers, if you've got a $12,000 signing bonus and you've got a 1-year term, you're going to earn that signing bonus each month of the term that you satisfy. So if you leave after 10 months, you would generally be responsible for returning $2,000 of the signing bonus. So a lot of dentists will go out and they'll spend their entire signing bonus, and then they'll leave after 6 months and they don't realize they've got to pay back half of their signing bonus. So important to remember that. So ration the signing bonus if you get one. From a legal standpoint, in terms of what you can negotiate in an employment contract, the first one is going to be the signing bonus, whether it's prorated based on your term or whether you can earn it all up front. If you couch it as a relocation bonus, it's going to be a lot easier to keep it if you leave before completing your term, as opposed to if it's stated as a true relocation bonus or as a signing bonus. And that will be specifically delineated in your contract. So it'll say whether you earn it over time, whether it's prorated and it vests over a period, or whether it's all paid and earned up front. Obviously, that's more favorable for the associate, whereas the vesting schedule is more favorable for the practice. Another thing that's important in terms of negotiating an employment agreement is looking at the restrictive covenants. Obviously, when you sign on with a new practice, the idea is not that you're going to be leaving the practice. The idea is that you're going towards something and you're going to spend a lot of time with that employer and that practice and grow with them. The reality is very few dentists are still employed by the first practice they worked for. So realistically, you likely will leave a practice at some point, and it's important for you to know when you're signing on with that practice what kind of restrictions you're going to have when you leave. Generally, you're looking at a couple different types of restrictions, all falling into the category of restrictive covenants. So those are going to be non-compete provisions, which would prohibit you from competing with the practice in a specific geographic area for a specific temporal scope, for a specific period of time, generally 1 to 3 years. Mileage radius in terms of the geographic scope of a non-compete will depend on the market you're in. So if you're in a big city, it might be a mile. If you're in a super rural, practice in rural Kentucky, it might be a 15 or 20 mile radius. It just depends on, in that specific market, how far people actually travel to go see a dentist. One really important thing to remember if you're looking at a restrictive covenant and you are joining on with a DSO or with a larger group practice that maybe has 10, 20, 30, 40 practices around, is whether or not your non-compete is tied to the specific practice you work for. So if it's at 123 Main Street, is the 5 mile radius just from that location at 123 Main Street, or is there going to be a 5 mile radius around every affiliated practice, that would really limit your ability to move around, especially if the practices are all centrally located around, one metropolitan area. So pay attention to that, and this is something where you can generally narrow that and say, look, I only want to be restricted from competing with the specific office I was working for, which really makes sense because, patients are going to follow you potentially if you move a mile or 2 or 3 down the road. But if you're moving 15 miles away, the fact that there's another affiliated practice around there really isn't going to impact the patient base, or at least it shouldn't. Another type of non-compete you'll deal with, and this comes up quite a bit, is either you can call them non-piracy or non-solicitation or non-poach provisions, but those relate to reaching out and marketing to specific clients of the practice you were formerly with, or more common actually is reaching out to employees of your former employer. So if you join a new practice and you encourage employees or your former coworkers to come join you, that can be a violation of non-compete provisions and your restrictive covenants. And generally, I would say practices care more about former employees poaching existing employees than they do poaching existing clients. If you look at a practice might have anywhere from 500 to 4,000 active patients, right? If you steal 5, 10, 20, 30 of those patients, it's really not going to impact the practice from an economic perspective. But if the practice has 10 employees and you take 1 or 2, that's 10 to 20% of the workforce. So that's a lot more impactful to the practice than patients, which is counterintuitive. Most people think, the patients are the payers, so that's who they care about. But it's really about protecting employees. So another thing to consider, and especially on the ethical side, is how to leave the employee of a practice. And, I think when you look at situations that I've dealt with where there's been hostility or litigation that's ensued after an employee has left or been terminated, mostly after an employee has left, it's been an employee leaving under not great circumstances. Generally, most practices and employers realize, hey, employees are fungible. They're going to move around, whether it's they're moving for a spouse or their kids, or they're just moving areas, or they just want a different experience. Most employers are okay with that. What they care about is that they're given plenty of time. So in my experience, as long as you as an employee give plenty of notice to your employer that you're going to leave, you're just simply not going to have a problem with the employer trying to enforce restrictive covenants against you. The biggest issue for employers, obviously, is keeping their workforce intact, and it's hard to find associate dentists. So if you leave and you give a practice a week or 2 weeks notice, that's tough for them. They've got to work on their schedule. They've got to reschedule patients. They've got to bring in new doctors. They've got to hire temporary dentists to come in, and that's expensive, and they can incur a lot of expenses that way. And frankly, it just pisses them off to the point where they're willing to pursue legal issues for violations of a restrictive covenant. And that can impact you not only from a legal standpoint of having to hire a lawyer and defend a lawsuit, but really from an employment standpoint as well. The last thing you want when you go to a new employer is to have your new employer get a letter from your old employer saying that you're violating non-competes. So from an ethical standpoint, and really from a legal standpoint, this is where they cross together. The better terms you can leave on, the better you're going to be off legally, as well as just from a general standpoint of having recommendations and keeping your reputation in the industry. So that's really kind of the two areas of employment agreements that you're looking at negotiating: the economic terms and then the legal terms. I know someone had asked a question about illegal employment agreements. That generally every different state is going to have different laws on non-compete agreements and how broadly they can be enforced, whether they can be enforced against employees, whether they can be as a subset enforced against healthcare practitioners, because that brings up patient choice and patient care questions that are public policy concerns that you're not dealing with if you're talking about an electrician or a plumber, something like that. So there are unique nuances to non-compete and employment law as it relates to healthcare practitioners. But I think a safe kind of rule of thumb is just assume that whatever agreement you sign is going to be enforced the way it's drafted. That's the safest bet. It's, I've had employees say, oh, well, I signed this, but I knew it wasn't enforceable at the time. That's a really tough argument to win, because you're saying you knew what you were signing and you understood it at the time and you had no intention of actually complying with it. So juries don't like to hear that. Judges don't like to hear that. And more importantly, it's really expensive for you to prove that. So I would say, look at your employment agreement, make sure you don't sign an illegal employment agreement. And the way you do that is by hiring an attorney to review it. So another thing to consider is that when you do leave an employer and you go to a new practice, that practice might want you to sign a document stating that you're not subject to any non-compete agreements or non-solicitation provisions, or that your accepting employment isn't going to violate any prior agreements with any of your prior employers.
Great. Thank you so much. That was very informative. I did have a follow-up question about terminations. Let's say you are being paid on a collections basis, and sometimes it takes 2 months, 3 months to get collections, and you've quit or you've left a practice and they're not paying you your collections after that. How do you go about enforcing that? Is that a common occurrence?
Yeah, that's a great question. Generally, what I would like to see if I'm negotiating on behalf of an employee is to have a specific provision in your employment agreement that addresses that exact issue. And there are a couple different ways you can do it. The easiest, at least from an operational standpoint, is just to say, okay, your practice, you are going to continue to pay me as collections come in over time, just as you have been in the past. That raises some problems from an administrative standpoint of, one, are you trusting what the practice is paying you? Are you extending your relationship with your prior employer to the point where you're getting paid by 2 different practices at once, which could raise some ethical concerns? So a good way to deal with that is to negotiate maybe a buyout at the time that you're leaving, to say, okay, this is historically what I've produced and what I've collected. So if I produce X amount and I generally collect 80% of that over a 3-month period, look at what you've produced over the last 3 months, and then have a buyout provision that just says that the practice will pay you 80% of that in a lump sum, and the risk of collecting more or collecting less falls on the practice after that. That's a good way to just kind of have a clean break there.
Okay, great. Thank you so much. The next question we have is, what is the top pitfalls dentists run into when buying and selling a practice? And what do the most successful dentists do when buying and selling for the first time?
Yeah, it's a good question. And I think it's important that as a young dentist, when you're looking at buying your first practice, or whether you're an older dentist buying your first practice, look beyond the financials of the practice. Really take a holistic approach in evaluating the practice and making sure that that is a place you can see yourself thriving as a business owner and as a dentist, and is it someplace you would want to work? You see a lot of practices that are extremely successful when you look at their income statement or their financials or their balance sheet, but they're not great places to work. And those are generally, associates that buy into practices like that don't end up being happy. Another thing, when I say look beyond the financials, if you just look at a revenue of a practice, it's not really going to tell you everything about the value of that practice. It's important to know what type of practice it is. So if you've got, for example, 2 practices next door to each other and each does $1 million in revenue a year, but one's a GP, you got 3. One's a GP, one's a Medicaid office, and one is an ortho practice. Those are all going to have very different valuations based on the same top line revenue. So your Medicaid practice that does $1 million a year in collections might sell for $700,000. Your GP practice that does $1 million in collections in a year might sell for 900 to 1.1 million. Your ortho practice doing $1 million in collections might sell for 2 or 2.5 million. So important to look at the different multiples in the different verticals of dentistry, as well as in addition to just the raw numbers, right? To figure out, okay, what's the long-term value of this when I go to sell? Especially with the roll-ups going on in the industry right now, a lot of dentists are, as before maybe 20 years ago or 30 years ago or 40 years ago, dentists were buying practices to buy and operate a practice for 30, 40, 50 years. Now you're looking at younger dentists trying to leverage debt to buy as many practices as they can, aggregate from an Ebitda standpoint, and then arbitrage it in a roll-up with a DSO. So all of those things become a lot more important because it's not just about the Ebitda that your practice is producing every year. It's about the multiple that you can get on that Ebitda when you go to sell, which really wasn't a huge factor 20, 30 years ago, but is a massive driver in the industry right now. You also want to look at a couple different things when you're looking at the financials. You've got really only, it's kind of an overused term, but you've really got two ways to increase Ebitda of a practice. You can grow your top line or drop your bottom line. I think a lot of young dentists look at a practice and they say, okay, I'm going to expand my patient base, and I'm going to get a higher fee schedule, and I'm going to grow my top line. And at the same time, I'm going to cut this expense, and I'm going to cut that expense, and I'm going to whittle down my staff. It's really, really hard operationally, especially as a young new practice owner, to work on both ends of your practice at the same time. So I think the most successful young associates I've seen, or any associates or any dentist buying practices, they look at a practice that they want to buy, they look at their target, and they identify a specific area, a single specific area of the practice that they want to improve. They say, okay, this practice is running extremely lean, extremely efficiently. I'm not going to be able to drop expenses. I'm not going to be able to cut expenses here. So I need to focus on growth, whether that's through patient growth, whether it's through getting better fee schedules, whether it's dropping fee schedules and going fee for service. Or alternatively, you might look at a practice and say, man, they've got 4,000 active patients. They're crushing it from a new patient perspective. They've got great fees, but their overhead is bloated. We can drop this contract. We don't need to use this group to collect. We don't need to use, we're overstaffed with either dentists, or we're overstaffed with hygienists or front of the office. So important to look at the specific practice that you're buying, figure out what the one area that you can really focus on growing that practice, and go from there. So I think to answer your question, the biggest pitfalls are thinking you can do too much. The best way to really create a successful practice is to buy a practice that is currently successful and figure out how you can make it more successful by changing one or two very discrete practices about the practice.
Thanks so much. That was a really great summary of that. And I think it ties in well to our next question of kind of what questions do we ask, especially before hiring a lawyer, looking into things with purchasing a practice, or asking those questions like you were talking about to avoid the pitfalls. So what would you say are the best questions to ask when hiring a lawyer when going into all of this?
Yeah, that's a good question. I get asked that question a lot, and I always kind of turn it around, like, how do you know if your dentist is good, right? You don't always have something to compare it to. How do you know if your doctor's good? How do you know if your cardiologist is good? It's usually recommendation, word of mouth. Oh, I saw this guy, or I saw this girl, and they were great. But when you're dealing with something that's a huge life decision, whether it's buying a practice or negotiating an employment agreement, you want to make sure you're dealing with an attorney who has experience in that specific field, right? I think that's the most important thing. You might have a brother-in-law who's a tax attorney or a real estate attorney, or your aunt is an estate planning attorney. You will do yourself a disservice if you use someone as your lawyer who doesn't have experience working with dentists in the dental industry. So the first question you should always ask is, have you represented dentists before? Have you represented dental practices before? Have you represented DSOs before? And I think your best lawyer is going to be someone who says yes to all three of those, right? You've got a lot of lawyers who only represent DSOs. You've got a lot of lawyers who only represent practice owners. And then you've got a lot of lawyers who only represent individual dentists. And everyone is going to have their specialties and their biases. But if you get a more well-rounded, holistic lawyer who's been on all different sides of the table, you're going to end up coming out a lot better. So I would say, that's number one. Do you have experience in this industry? Number two would be, do you have experience with this specific practice, this specific dentist, this specific DSO? Because everyone is different, right? Certain DSOs or practices really care about restrictive covenants. Others really care about the economic terms. And it's important to know, if you use an attorney who's worked with those groups before, they can tell you, hey, I've worked with these guys and they're going to push really hard on these provisions, but I trust them. I've represented 30 different dentists who've signed on with them. And yeah, we're giving up a little bit over here on the contract, but I promise you they're going to take good care of you. So let's push harder over here. That's important. Get references. Obviously, that's always a good way to do it. I would say the one thing, and this is probably the most common question I get asked, is what's your hourly rate? Which is a terrible question, right? Because it only gives you half the equation. If you're going to ask someone what their hourly rate is, you should also ask them how many hours they're going to spend on your case. Because a lawyer who charges $100 an hour but spends 100 hours on your employment agreement, I'd rather have a lawyer who charges $800 an hour and spends 2 hours on my agreement. So if you're going to get the same work product. So I wouldn't always pay attention to the specific hourly rate. I would get a ballpark estimate of what it's going to cost. And I wouldn't penny pinch either. When you're talking about negotiating an employment agreement, especially, you're really not looking at a lot of money. You're looking at $1,500 to, I did a deal a couple of weeks ago representing a dentist and an associate in connection with his practice selling to a DSO. And it was a super complicated employment agreement with some equity structures in it. And it was like $7,000. And, compared to the amount of money he was going to make out of the deal and the specific benefits and provisions we were able to negotiate, that $7,000 he spent he'll get a return in spades, right? And if he had spent $2,000, yeah, he saved $5,000, but he probably would have cost himself 50 doing that. So I would definitely, now if you're talking about buying a practice, it's a little different story. You're looking at, $10,000 to $30,000 probably in legal. And it just depends on the other side too. A lot of DSOs are going to use big firms and they're going to have, $150,000 in fees on their side of the deal. So that can always increase your fees. But for the most part, I would get a ballpark from your lawyer and don't penny pinch unless you are paying a significant percentage of the transaction price towards your legal.
Great. Thank you so much. Our next question is, what are the top reasons for being sued and how can we avoid those? And I know earlier you talked about when you terminate or when you're stop working at a practice, just leave on good terms. But are there other tips that you might have for us?
Sure. Yeah. And I think you're going to deal with, as a dentist, especially as a business owner or a practice owner, you're going to deal with two different types of legal issues for the most part. You're going to deal with patient legal issues and you're going to deal with employee legal issues. So I'll kind of break those down and talk about the different ways to avoid liability. And look, I think at the end of the day, no one is perfect at their job. Everyone is going to screw up from time to time, whether it's you screw up a filling or an amalgam, or you just didn't do a great job on a crown or something, or you screw up, you hire the wrong person, or you make a mistake in, the interactions you have with your employees. Everyone's going to make mistakes, right? Um, it's how you deal with those mistakes that's really going to impact whether or not you have liability. And more importantly, it's not always whether or not you have liability, it's whether someone is going to pursue you for that liability. That's what really matters. There's liability out there all day, every day that people don't pursue, right? And for any given number of reasons. But no one's ever gotten hit with liability when they haven't been sued for it. So the first line of defense is always, how do I avoid getting sued? Because you are going to make mistakes. You are going to have liability floating out there. And I would say the number one reason people get sued by patients is communication issues. Communication is super important. At the end of the day, whether you're a lawyer, whether you're a waiter, whether you are a dentist, you're a service provider and you're in a service industry. So it's about the way you make people feel. And if someone trusts you and likes you and you make them feel good and you're open and honest with them, they're going to forgive you if you screw up, right? And if you treat them well and say, hey, come on back in, I'll replace that filling for free or whatever it is. Those are great ways to curry good favor and loyalty with your patient base. Mistakes are actually a really good opportunity to create brand ambassadors, right? It's a new type of interaction you're going to have with your patients, and your patient might say, man, my dentist screwed this up, but it was awesome. He brought me in on a Saturday, or she brought me in on a Saturday and fixed it, didn't charge me anything, and gave me a free Zoom whitening or something like that. And now you're creating loyalty and a brand ambassador out of really something that was a mistake and could have been a problem and could have led to a lawsuit. So communication is key. Communicate with your patients on the front end and especially on the back end as well. Make sure they know exactly what's going on. Tell them if you screw up, hey, here's what I did. It happens sometimes. Here's the way we fix it. So I would say number one reason doctors or dentists get sued by patients is because of a breakdown in communication. So if it doesn't matter how bad you screw up, if your patient likes you and understands the process, it's really unlikely that they're going to pursue you, whether it's through a board complaint or a lawsuit. If they don't like you, if you don't accept responsibility, if you're not open and honest with them, or you try and cover, that's when you get into trouble. And one way that comes up a lot is, patient interactions aren't always fun, especially when something hasn't gone, according to plan. And a lot of dentists, either they're busy and they've got to go to another room, or they just don't want to deal with the comfortability of the interaction. So they delegate the communication to an office manager or an assistant. And that will oftentimes lead to a breakdown in communication. One, because at that point, you're not controlling the communication, you're not controlling the narrative, you don't know exactly what they've said, and you don't know how they're going to handle the patient feedback. So really important that you take ownership of the communication and control the narrative that's being delivered to the patient, and you answer their questions. So communication is number one. That will stop you from getting sued. Good communication. Obviously, you're not always going to be able to stop. There are people out there who, no matter how nice or how well you treat them, they're just going to sue you and they're going to get pissed off. So the number one reason for getting sued is a breakdown in communication. The number one reason for losing a lawsuit is a breakdown in documentation. Keep excellent notes. Super important. And I know it's hard. You're running from room to room and patient to patient. It's really important that you document everything that's going on. Delegate where you have to, but as much as you can control the patient file, that's your patient file. That's something you own. That's not something the practice owns. That is your patient file. And that is all really that's going to be in front of the court, along with the experts testifying. But the patient file is going to be the primary best evidence of what took place and whether what took place was appropriate or not. So stay on top of your notes. Don't delegate important documentation to staff. And just know that, it's important to document everything you're doing, because it's, if you've got 3,000 active patients and you're testifying 2 years from now about a filling you did or a crown or root canal 2 years ago, unless you have those patient notes and they're good, thorough notes, you're just simply not going to be able to remember what happened. So that kind of deals with the patient side of liability. I would say much more common as a business owner, as a practice owner, as a dentist, is employment issues, getting sued by employees. Then the number one kind of advice I give to employers when making hires is trust your gut, right? If you get a funny feeling, there's a reason for that. So who you hire is extremely important. Check references. That's important, but also just absolutely trust your gut. And similar to patients, you have really two reasons that you're going to end up in employment litigation. And that's the same exact reasons as with patients. It's a breakdown in communication and a breakdown in documentation. So I get a lot of business owners who are very reticent to keep formal disciplinary records because it seems draconian to write someone up for being 10 minutes late. It's a lot easier to pull them aside and say, hey, let's really work on being on time. The problem is when you do that, you are not creating a record that's going to give you the ability to terminate someone if they don't get on the right page. So for example, if someone's consistently late and you're like, hey, you need to be on time. Next week, hey, you need to be on time. Hey, you need to be on time. And you finally get pissed off and say, look, you've been late 15 times in the last 3 weeks. I got to terminate you. Well, what record do you have other than your word that they were actually late? Very, very important that you document that. And, it doesn't necessarily, it doesn't have to be a punishment. It can just be, look, hey, employee X, this is just our policy. I hate doing this. It seems really formalistic, but look, we just have to do it because our lawyers make us do it, So just sign this saying we gave you a warning, sign this saying we gave you a second warning, sign this saying we gave you a third warning. And it's employees, a lot of times they don't want to sign it because they don't want to admit fault. That's fine. Just document employee did not want to sign. But keep really good notes about your employees. And I hate using the word write up because it sounds like you're in 7th grade getting written up for a demerit or detention. But really important that you keep that documentation so that when it comes time to terminate someone, you have the track record and the paper trail that you need to support that termination. So document. The other one is communication. And this kind of gets back to the ethics of just being honest with people. People really, really appreciate honesty. And I can't tell you how many times I've had employers get in trouble for terminating an employee and lying about the reason for termination. And it's not nefarious, it's not malicious, it comes from a good place. Employers no one likes terminating employees. So you want to sugarcoat it as much as possible, right? If someone's just a bad employer, they're consistently late and it's like time to get rid of them. You say, hey, Adam, I'm sorry, we got to let you go. We just don't have enough work to keep you on board, right? That's a very common statement that an employer is going to use to terminate an employee. The problem is when you get sued by the employee, and this happens every once in a while for discrimination or for wrongful termination or constructive discharge or whatever it is, you now are stuck by what you told the employee, right? Number one reason for employers losing employment suits is a change in reasoning for termination. So at the termination, they say, hey, we just don't have enough work to keep you on board. And then when the employment suit gets filed, they're like, oh, they were a terrible employee. We terminated them for cause because they were late, and they exceeded the scope of their responsibility and, failed to document patient concerns, stuff like that. Well, now you've changed your story. And so there's going to be a presumption that you are making up the for-cause reasons that you may have to terminate an employee. So it's very important that if you're terminating an employee for tardiness, you tell them, I'm terminating you because of tardiness. If you're terminating them because they exceeded their scope or did something improper, you tell them that's why you're terminating them. One, I promise you they will appreciate it a lot more. And you're doing a disservice to them if you tell them that's not the reason. If you say, hey, we just don't have enough work, they're not going to be able to internalize that and realize, oh, hey, I got fired because I was late. Maybe I should work on my punctuality. But also it's just a lot simpler from your perspective because you're not going to have to keep up with it, right? If you tell someone, hey, we're getting rid of our second hygienist because we just don't have enough hygiene to support 2 hygienists, and then a month later you hire a new hygienist, it's going to look really bad when that employee comes back and sues you and says you terminated them because of their race or their sexual orientation or something like that, and because it's going to look like you were making up a reason for terminating them. So again, kind of everything we talk about has come back to communication and documentation, and those are the 2 most important things when you're dealing with liability.
And I had another question for you regarding that as well. Just going back to the patient portion, do you ever
Yeah.
see office managers or anyone else documenting interactions with difficult patients, or how do you recommend that documentation process? I know it can be a little tricky putting notes in about the patient's demeanor and things like that.
Yeah, you've got to be careful, but I would say it's look as a dentist, um, you now there are certain exceptions, right? Emergent circumstances, continuation of treatment, but generally you're not required to continue to treat a patient or see a patient in non-emergent circumstances. You're a business just like anyone else, and if you don't want to service a patient because they're difficult or they're abusive to your staff, that's fine. You have every right to do that. So documenting that is important. I would say um, those interactions generally aren't going to lead to legal liability. What you're going to run into uh, is reputational liability, because your patients who cause scenes in a waiting room or cause scenes or in an operatory or are abusive to your hygienist or your staff, they are the ones who are going to go to Yelp or WebMD or whatever it is and write negative reviews about you. And if you've documented what they've done, it's not really going to help you because you're not going to be able to put it on Google or Yelp or whatever it is. You're just not going to be able to do it. So I would say get rid of troublesome patients early, before those things can happen. And that's really, it's less of a legal liability. It's more of a reputational liability. But you'll get it. You will absolutely get it. And people will be difficult, just like they are at restaurants and at banks and everywhere else.
Awesome. And then I think we have one last question to kind of wrap it up. What are the top ways that you would advise navigating kind of tricky situations, like when to get a lawyer involved, things like that? I know you've touched on it a little bit, but any final remarks on that?
Yeah. I would say probably the same thing that you guys would say to your patients. Don't try and, you know, solve a dental problem yourself. Don't try and solve a legal problem yourself. I don't fill my own cavities for a reason. I don't do my own taxes for a reason. I'm not a tax lawyer. I'm not a CPA. I'm not a dentist. And usually if I have a legal issue, I'm going to hire another lawyer to do it. So I would say if you have any concern whatsoever, and it can be as simple as just kind of a feeling in your gut that this doesn't sit right, reach out to a lawyer. The majority of lawyers out there, contrary to our reputation, we are really here to help. And if you can establish a relationship with an attorney to the point where you can call them and they know your practice and they know you, and you can say, hey, I had this interaction today, what should I do? They're going to be able to tell you right off the bat, hey, do X, Y, or Z. And if you get a bill for $250, okay, you get a bill for $250. If it's a good lawyer, they're probably not going to charge you. right? Because they're fostering a relationship with you. And when you actually get sued and have $100,000, legal bill, that $250 they wrote off will be totally worth it. But reach out early and often, especially if you're with a larger practice or you're with a DSO. Those groups generally have lawyers either in-house or on call, outside counsel. And that's one of the benefits of being with a DSO or a DPO or whatever it is. Those are resources that you can use, and you're paying a fee for it. So use it as much as you can. And it's a great way to avoid liability, is to reach out early and often. You see those signs at the airport. If you see something, say something. That's very, very true of legal and employment issues in the dental industry. Reach out, ask someone what the best course of action is, and they should be able to guide you.
Awesome. Thank you so much, Braden. I learned a lot today about employment contracts, buying and selling practices, common legal issues, and how to find someone like you when we need to. I love how you said you don't fill your own cavities or do your own taxes. That's a great thing that we should say to our patients. A common theme I heard today was communicating clearly and treating people well and not burning any bridges can help us avoid legal issues. And I loved that because we really want to avoid the issues. And when they do come up, we want to document it very well and reach out to someone like you. So thank you for teaching us about the legal things that we aren't taught in dental school. I know the rest of us SPIA members are going to be very thankful and learn a lot once we watch this. Thank you so much for your time.
Absolutely. Thanks for having me.